Good afternoon, everyone, and welcome to today's e-learning session on changing my employees' terms and conditions during COVID-19. So the detail contained within this e-learning session is based on Republic of Ireland employment legislation. Clients in the jurisdictions of Great Britain, Northern Ireland, Jersey, Guernsey and Isle of Man are asked to please contact the advice service to obtain the information relevant to your jurisdiction. And so as always, our Peninsula 24-hour advice line is available if you've got any questions or queries. It's manned 24 hours a day, 7 days a week, and two main numbers for you to ring. On Dublin 01855 01855 5050 and in Cork on 021 212 9917. And not only for advice, but also to obtain standard documentation and templates of letters from which you can draft communications to your specifications with our assistants. And it's particularly important if you have taken out the insurance policy with us. Well, I hope everyone's safe and well. My name is Patrick Whelan. I'm the Employment Consultancy Manager here in Peninsula. And today we're going to cover off changing your employees' terms and conditions during COVID-19. And here's the agenda items that we're going to cover off. And the first half is kind of giving a background there and being really clear about what are express and implied terms. And then we'll go on to discuss about contractual terms versus work practices, some of the legislation behind it all, and then obviously your change options. What can you do to change and the associated risks if you don't follow the correct process. We'll outline the process then and provide a handy checklist at the end, and then just do an overall summary. And I suppose in light of COVID-19, and especially now, I suppose, since we have the return to work safely protocols in place, the schemes, the temporary wage subsidy scheme, there are no doubt a need for employers to change terms and conditions and work practices, all brought about by COVID-19. And so we want to do that in a safe way that you're not exposing yourself to risk. So any questions arising from today, I'll try to answer a few at the end, given some time constraints, but we'll always endeavour to make sure that you get the questions answered via email as well. Okay, so let's look at express and implied terms. So in every contract of employment, written or otherwise, there are four categories of implied terms which fall under the headings of terms employed by custom and practice, depending on the industry. So there might be something so notoriously well known within an industry that it's not written down anywhere, but everybody accepts it. And so it now becomes custom and practice. Okay, so, for a long time in the construction sector, for example, travel money could be employed as an implied term through custom and practice. Another one then is terms employed by statute, obviously, right to redundancy, right to not be unfairly dismissed, right to notice, right not to be discriminated against as per the Employment Equality Acts, right to breaks, annual leave, holidays. So they are all in their statute. They're put in by the legislation, and especially now we're looking at the Health, Safety and Welfare Work Act 2005, which has its own implied terms in there. And then terms employed by law, so employer's duty of care and employee's duty of trust and confidence that are in every contract of employment. And then there's collective agreements and unionized employment. So some of you will have collective agreements, and we talk about collective bargaining a little later on. So they're the implied terms. When we talk about express terms then, are terms clearly agreed between the employer and employee and can be oral or in writing, but they're expressly stated, as it were, and when we talk about express terms, it's good to reference, and they're usually referenced in your statement of main terms, so in the SMT, and I've just listed there the 15 or so core terms that should be covered in any statement of main terms, and these are the ones really that you're going to be varying around this time. It's important, I suppose, to distinguish between contractual terms and working practices, and that's quite useful in terms of return to work safely protocols and some of the obligations that are mandatory there for employers. Some of them, for example, staggering shifts, people going on breaks at different times and things. So it's good to talk about that right now. And so there is a distinction between contractual terms of employment and work practices that are not contractual in nature. And so while a work practice, for example, e.g. modernization of workspaces, may be changed by an employer unilaterally, a contractual term, e.g. pay, pension scheme, hours of work, may not be altered without an employee's agreement, and this could amount to a breach of contract. So that's really important to distinguish between the two. What's a contractual term and what's a work practice? So we have to get some sort of agreement on contractual terms, and I say agreement loosely, kind of, because some of it is a fait accompli at the minute, but work practices you don't. So the change that most employers are looking to effect, I suppose, is a reduction in employees' salaries, and this is not surprising given that this is the most significant employee-related cost for businesses. So salary would, however, constitute a term of employment rather than a work practice. And as such, it cannot be varied unilaterally. So you just can't make the change and say, hey guys, this is what's happening. While some contracts of employment contain a clause which expressly reserves the employer's right to make amendments to an employee's contractual terms and conditions of employment, a variation clause must be exercised reasonably at all times. And I'll give you an example of that clause, but the word reasonable is going to be littered throughout these slides. So any actions that you take need to be reasonable given all the circumstances. And I talk about reduction in salary there, for example, employers who are on the temporary wage subsidy scheme right now and who are paying 70% or 85% of employees' wages and not topping up. Well, effectively then, and employees are still working the same hours, effectively then that the employee has received a pay reduction, and ultimately their terms and conditions have been varied. So has that been accounted for in their terms and conditions of employment? Okay, so again, just to be more specific, contractual terms include pay, hours of work, sick pay, and pension scheme. So not all of your contractual terms may be in the written statement of your terms and conditions of employment. Some might be in your staff handbook, in policies and procedures, a pension scheme booklet, or a collective agreement. So if you're in the construction sector, you might refer to a sectoral employment order, or for contract cleaning or security, an employment regulation order, for example, or some other booklets that you have. Work practices then include breaks and rostering, for example. And so if we're talking about staggering shifts or changing breaks, that's a change in work practice. And that's a mandatory change as well, because return to work safely work protocols outline that. So that 29-page document is incumbent on employers to implement to ensure social distancing and to prevent the spread of the disease in the workplace. So it's considered reasonable for an employer to update work practices or process to save money or increase efficiency, and obviously to comply with mandatory requirements as well. Okay, just to quickly look at the governing legislation, because this is all underpinned by governing legislation. We're not picking it out of the sky, and it's just to be mindful of that. And terms and conditions, the Terms of Employment Information Acts 1994 to 2014 also set out the terms in the contract must be put in writing. So if you don't have contracts in place, now is a good time to issue them. It's never too late to issue them. But every new employee or every employee should have on their personnel file a copy of their signed contract of employment, which will outline their at least 15 of those points I outlined in the earlier slide. But generally their name, their job title, their company address, the date they commenced their employment, their rate of pay, their hours of work, the main thing that's going to affect their pocket, as it were. And this requirement that an employee receive a written statement of terms of employment then is set down under Section 3. Okay, and you'll all know as well, if you've got new employees starting into your business, that they need to have 5 core terms within 5 days under the Employment Miscellaneous Provisions Act. So best practice, give that statement of main terms before they start and get them to sign it. Okay, Section 5 then of the Terms of Employment Information Act provides that where an employer makes a change to any of the particulars of the statement of the employee's terms and conditions of employment, the employer must notify the employee in writing of the nature and date of the change within 1 month of the change taking effect. So in practical terms, notification of a change of a change terms will only suffice where the change is not related to a core term or condition of employment. So this section cannot therefore be used to force through any changes to fundamental or significant employment terms. So using that TWSS, the temporary wage subsidy scheme example, if you're paying 70% or 85% and not topping up, well, an employee has in their terms and conditions of employment, in their contract, in their statement of main terms, they'll say what salary they're getting. And if they're only getting 70 or 85%, well, there's associated risks with that straight away, and I'll cover them off. But strictly speaking, that's a significant change in their terms and conditions, and that they'd need to be notified of that, at least within 1 month of that change. Okay, just to briefly touch on this, because this was flagged as well by the Department of Business, Enterprise and Innovation. So the Employment Permits Acts, there were some changes there as well. They set out the terms and conditions for granting an employment permit, including employer details, location of employment, job role and remuneration. And currently, the department does not require employers and employees to apply for a new employment permit if minor changes are made to these terms and conditions over the lifetime of a permit, such as a change of occupation title with the duties remaining largely the same, or a change of work location, or such changes, however, or work location, and such changes, however, must be notified to the department. Other more significant changes to terms and conditions of employment, such as changes to remuneration, contract conditions, would be regarded as material changes, and as such, new employment permit would normally be required. However, in light of the current COVID-19 situation, the department will seek to be as flexible as possible and will consider these situations on a case-by-case basis when brought to the department's attention. So, just in terms of any changes to employees, non-EEA nationals who have employment permits, just be mindful in that regard. Another thing to be mindful, I suppose, in terms of changing terms and conditions of employment is to keep evidence of all this. Part of the criteria for the temporary wage subsidy scheme is somewhere down the line they might require you to produce eligibility that of the scheme. So in your self-declaration, you will also need to prove that you're eligible to receive these supports. And one of the things was copies of notifications or communications to employees or trade unions or staff representative bodies of salary or wage cuts implemented as a direct result of the COVID-19 pandemic. So having, varying employees' terms and conditions, having a paper trail as well ties in with the TWSS if you've made any changes there. Now, in general, revenue know all the sectors that have been affected, and the emergency period is for 12 weeks, and more than likely the scheme will be extended beyond that. But to be mindful that any notifications, keep them on file, and they will substantiate your eligibility in terms of your inability to pay normal outgoings, or, for example, you might have reference to 25% reduction in revenue. So you have some options when it comes to changing or varying terms and conditions of employment. Same thing, really. So again, when we're talking about terms and conditions versus work practices, you can't unilaterally force through changes in terms and condition of an employee's contract. Okay, so the only safe way to change a contract is by agreeing to change with the other party to the agreement. So it's a contract. When an employee starts, here's your terms and conditions, they sign it and we agree to work to it. And so that's a written agreement. So any changes after that, then there needs to be an agreement, and safe way to do it is by agreement. It may also be possible for an employer to vary an employee's contract by including an express right to vary the employee's contract of employment. However, the ability of an employer to rely solely on general variation clauses to unilaterally change a term or condition of employment is limited. And so that's generally reserved for where, for example, legislation might dictate that you have to update a contract of employment, or you might need to make reference to something, and so their terms and conditions change, but you don't need to seek agreement, but you will need to give them notice of the change. So there'll be greater scope to unilaterally impose changes to a term or condition of employment where the particular clause in the contract contains specific variation clause, e.g. permitting an employer to change the place of work of an employee. However, even where a variation clause exists, changes cannot be forced through unreasonably and generally will require employee consent for significant changes. What we mean by that is, if somebody right now, if somebody's working in Dublin, and there's a flexibility to clause to say we'll require to work you with various locations as and when required, and now you're asking them to work in Cork. Well, how reasonable is that? So you're affecting a change, but the change needs to be reasonable and needs to be discussed, especially consent for a significant change like that. Okay, so you can't unilaterally force through changes, but right now, I mean, employees are generally accepting and understand the situation with COVID-19, but there's still a process that you need to be followed, and common courtesy and communication is really, really important, that you're communicating to employees around that, and we'll go through the process. The express wording that you'll see in a lot of your SMTs that we've drafted is that we reserve the right to make amendments to your terms and conditions of employment, and we'll provide you with 28 days notice of any change coming into effect, taking into account the requirements of the business. And so that's in line with the Terms of Employment Information Act. It still doesn't give you carte blanche to change them without telling them. You still need to agree at least. Okay, so if you just unilaterally force through changes, if you just go ahead, right guys, we're going to, I'm reducing your salaries, we're cutting your hours, and this is the way it is because of COVID, or not even telling them that. I mean, the good thing about COVID is that you have a strong business case to do so, because the alternative is, worst case scenario, closure of the business or redundancy for the concerned employees. So there is associated risks with just steamrolling changes through. And the main risk, I suppose, is a breach of contract. So an employee could take a case to the civil courts, for example, for breach of contract as part of such a claim and seek injunctive relief. So they could get an injunction against you for, it's an expensive method, I suppose, for the employee, but they get an injunction, a temporary injunction, basically to say that you're not going to dismiss them, or sorry, you're not going to make the change. So they can put a pause in that change. So this is more costly option, as there's a risk that an employee would bear the legal costs of the company were they to lose. Okay, so breach of contract claim, to go to the civil court and get an injunction to stop you making that change, put a pause on it. Another one would be claim for constructive dismissal under the Unfair Dismissals Acts. So an employee could resign and claim constructive dismissal on the basis of a fundamental change to the working conditions, or that the company acted unreasonably by amending the contract without consent. So there's a high onus on an employee in such cases then to show that the change made the working conditions intolerable, and they must have first dealt with any grievance through the company's internal procedures. The maximum compensation that can be awarded is 2 years gross remuneration. However, the award will be based on financial loss and is subject to employee's duty to mitigate this loss by finding alternative employment. So worst case scenario, for example, in constructive dismissal, where the onus is on the employee to prove that they were constructively dismissed, that the employer was so unreasonable in the circumstance that the employee had no alternative but to resign, because no reasonable employee could stick around. But in order to do that, they need to exhaust internal mechanisms. They need to raise a grievance, follow the company's internal procedures, give the employer an opportunity to address the situation. So the onus is on the employee in this instance to prove that constructively dismissed, while unfair dismissals, for example, is onus on the employer to prove that they followed the correct process. Financial loss is obviously hard to mitigate at this time round for COVID-19, because finding alternative employment might prove difficult. So they might well get to 2 years, but they have to show that they made efforts to mitigate their loss. Industrial Relations Act is another option there. This is more concerned, I suppose, with unionised employees, where they'll bring a trade dispute. So it's not particularly that relevant, but it's just something to flag. A trade dispute is defined extremely widely and can cover situations where employees are not happy with the procedures followed by a company in varying their conditions of employment benefits. I suppose the other main one then would be the claim on to bring a claim to the WC under the Payment to Wages Act 1991. So where the changes to their pay or the change to their hours affects their pay negatively, a disgruntled employee could also take a claim to the WC under the Payment to Wages Act, claiming that there's been an unlawful deduction made to their remuneration. So that's where I talk about you're not topping up their pay, they're still only getting 70% when they should be getting 100%. or they're changing their hours that affects their pay negatively as well. So those two options there to giving a payment to wages claim. So there are the risks. Just to touch on collective bargaining then, I suppose that's the process where employees come together and through their trade union, they seek to negotiate terms and conditions of employment. So obviously employers don't have to negotiate with trade unions and don't have to recognise them in Ireland. In this scenario, the employees have an opportunity to vote on whether to accept or reject the terms, and if approved, then the terms of the collective bargaining agreement effectively become the terms of the employment contract, and the employer then will be legally bound to comply with the agreed contract terms. So it's a group of employees coming together. They'll have like a forum, somebody will represent them, either a trade union or somebody, and they'll discuss with the employer the terms and conditions, and then they come to an agreement. Employers with more than 20 staff should then also remember that where there's a failure to reach agreement, unions may apply for formal recognition in order to collectively bargain on behalf of employees. This may result in collective agreement being formed between the recognised union and the employer, and in that instance then the labour court ruling would be binding on the employer. So it's best off if you've got a large number of employees to try to collectively bargain at local level before it goes to the labour court and have been imposed upon you. So while the process may, increase timescales involved in the process will have an emphasis on reaching voluntary agreement, the right to request formal recognition is protected under law. So ultimately, any collective agreements that cover employees must be outlined in their contracts of employment as well. Okay, so we can't unilaterally force through changes to terms and conditions. So how do we go about it? What's the process? Okay, well, the first thing, you need to get your house in order and have a clear understanding as to why you're going to affect these changes. So you need to know your business case. So establish clear and well-researched business reasons of why things need to change. So you've got a burning platform right now. It's COVID-19, so lots of different scenarios there. If your business case is robust, then it will reinforce your position that there's a genuine requirement for change. It will also allow you to respond to challenge without mixing the message. So this must be robust and stand up to scrutiny before you make any announcement for change. Okay, so you're that's pretty straightforward. You're being straightforward there. You're being reasonable as well, and you're able to point to facts and figures to demonstrate the fact that this is my business case. I suppose once the genie's out of the bottle, then it can be difficult to backtrack, and any fundamental flip-flop may leave your employees wondering about your intentions or worse, your competence. So your message will be consistent if you've done your homework. So your rationale will be clear, and importantly, your staff will see that there's a clear business need for that change. So get your house in order, make sure you have a robust business case. That's the story you're sticking to. And that's ideally what you want to be communicating to your employees. We're affecting this change because of A, B, and C. So what you're talking about then is really having a good communication plan in place. Have this mapped out for yourself so you know what you're going to do. So whether it's one employee, a small group, or an entire workforce, prepare for how you're going to deliver that information about the proposed changes. And more importantly, what are your timescales in order to consult with everyone involved? Okay, so how soon do you need to affect this change? Is it business mission critical? You mightn't have this luxury of time, so you need to do your homework and do your maths on it all, but certainly have a communication plan. Communication is going to be key throughout this. So consult and try to seek agreement where possible, and allowing for time, obviously. So be willing and ready to listen, and more importantly, take on board or try out suggestions. Okay, you want to be seen to be trying to seek suggestions and alternatives, and giving people the opportunity there, perhaps. Simply repeating the need to move things forward because of a deadline will make you appear rigid, unreasonable, and make things more difficult to get where you want to go. So again, keep a paper trail of this. You're demonstrating that you've been reasonable in this process, that you're trying to be as reasonable as possible to affect any changes, and that these changes are necessary. And I suppose the most effective way of announcing a possible change in terms and conditions is to meet with staff and their representative in groups. Okay, so if you're already opening, you're sticking with social distancing, you can do it over Zoom or life size, whatever. best off face-to-face in some medium anyway. And this allows you to maximize your audience, deliver a cohesive message and reduce the chance for gossip via the organizational grapevine. So they're hearing it direct from the horse's mouth. However, in doing so, remember not to overlook the importance of consultation on a one-to-one basis and take on board any individual concerns. So you'll know the employees that might cause a little bit of trouble or whatever. You might want to talk to them first or address any concerns. You know your teams. There's no one-size-fits-all approach. But you know, face-to-face is best off in that scenario. And then obviously don't be deterred. So at the first sign of resistance, obviously people are going to question, they might put up some form of resistance, but you know, maybe give them a bit of time to digest it, re-examine the proposal and evaluate the landscape, how it has changed, you know, and things are changing all the time, especially with the phases, you know, and the, you know, the safety protocols, the reopening, guidance from the government is living documents and subject to change. And so you need to keep an eye on them as well. And maybe your business has changed, maybe you can't reopen. So time is also a helpful tool in allowing space for real consideration to take place. But that comes back to your robust business case there. So maybe that time is not of the essence and this is what's need to happen. Okay, so just to summarize the process then. Maintain clear communication with employees. That's really, you know, displaying empathy. Be transparent. Don't hide anything in that regard. Provide employees with reasonable notice of any variation to terms and conditions. That's important too. Be able to explain why the change is necessary and inform the employees of the alternative. You know, if we don't affect a salary reduction or a reduction in hours, or we're changing work practices, well, we're changing work practices is not changing, you know, explaining to them that it's not a contractual term, that it's a work practice, and a work practice in terms of staggered hours or breaks is not a term and condition, and you being clear on that as well, because they mightn't be clear. And then maybe as an alternative, if you can, for example, you know, a spoonful of sugar helps the medicine go down. An incentive can be suggested perhaps, or down the line, for example. But you know, that's you know, number 5 is just where you can. It's not a requirement, and this is a suggestion. It's not one size fits all approach. It's just a guideline. You know, again, the likelihood of success, by doing that, you're minimizing the chances of a breach of contract, a constructive dismissal claim under the Unfair Dismissals Act, or a Payment of Wages Act. Okay, so you're ticking all these boxes that that you had a burning platform, that you had a business case, that you were reasonable, and that you've documentary evidence of all this, and you've consulted and you've spoken to employees about it. In terms of a checklist that you could go through, and this is, you know, no one size fits all again, but you know, for you, if you're looking at things right now, you know, be clear yourself. What is a contractual term or what is a work practice? So even if the term that is changing is not set down in contracts, okay, how long has it been in existence? So bear in mind what I spoke about earlier, that custom and practice is it so notoriously well known that it's become a, you know, a contractual term. You know, so an employer needs to consider if it has potentially become an employed term or a matter of custom and practice. Okay, so review all contractual and policy documents for references for the term benefit to be changed. So note the documents and clauses that will need to be amended. Okay, so that's where you can get in contact with Peninsula. So we can change the templates on your portal. So if you log into Bright HR and you go to your portal where you're going to access your documents, we can change them, you know, put up a temporary one, or you're contacting the advice line on 01855 50 50 to assist with, you know, an amendment to terms letter, you know. So all this, you don't need to go reinventing the wheel is what we're saying on this. We can help you out. We're here to help. Review any collective agreements to ensure the proposed change is not connected with a term agreed collectively. And so then if it was already agreed collectively, then union consultation or an accepted body consultation may be required. So then check if there are any industry specific agreements. So sector employment order, employment regulation order, these agreements may set out specific rates and terms and conditions that cannot be changed without agreement of all the parties to the document. Okay. Going on number 6 there, is there a right to vary terms and conditions in the contract? So it is still highly recommended that an employer seeks employee consent, especially if it's a significant term that is changing, e.g. pay, location, hours, for example. So ensure the proposed change is still in compliance with employment legislation, working time, minimum wage. So if you are reducing people's salaries or wages, you know, and their hours of work are still the same, Well, obviously now you need to ensure that they're not going below the national minimum wage of 10.10 an hour, or at least not below their sector employment or employment regulation order wage. So that's just something to be mindful of. You still need to fall within the law. Okay, then you need to, for example, if the change is a reduction in hours, be mindful that short time and layoff can give rise to redundancy situation. I've discussed this before, and that's temporary on hold until the 31st of May. So the Emergency Measures Bill came into effect, and some lobbying by Chambers Ireland, and in particular Alan Hickey on the Employment Task Force, our own associate director here, managed to get a temporary pause on redundancy. So generally after 6 weeks on temporary layoff or short time, people can be made redundant, can apply for redundancy. There's a temporary stay in that on the 31st of May. We are lobbying at the minute right now to get that extended, so watch this space. But prolonged redundancy after the 31st of May will keep you updated, and that may lead to redundancy, or layoff or short time may lead to redundancy. Consider whether the change can be phased in over a period of time to ease employee acceptance of the proposed change. That's an option. Are there any employees who will be more affected than others by the change? How will this be dealt with? Consider more in-depth consultation with those employees. So maybe not in a group, take them aside. Consider if any compensation will be provided to employees to compensate for the change. That's only where possible. That's kind of a sweetener. Draft the contract wording for contracts and policy documents. Again, that's what we're here for. Draft a consent letter allowing the change to be signed. So a contract amendment letter, for example, outlining the change as discussed in our meeting on such a date, and we're affecting this proposed change. And if it's a temporary change, how long it's going to be for example. Be clear on the reason for the change internally and agree employee communication plan with your manager. So everybody needs to be singing off the one hymn sheet on this. Should be no deviation. So everybody is clear in what they're talking about. Best practice, arrange a consultation meeting with employees to advise them of the proposed change. So when I talk about consultation, it's not like, it mightn't be the case that, we don't want the tail wagging the dog, but certainly you need to meet with them. But ultimately, it could be a fait accompli. Look, it's how you just deliver that message. This change is happening, not like it or lump it, but setting out the business scenario and then delivering it in a HR way, I suppose, taking into account everything that you can. And then, consultation with employees should include information on the following. So you're giving them the information, you're being transparent as to the details and the reason for the proposed change. So why are we doing this? They might be oblivious, but they shouldn't be with COVID-19. But again, you need to make them aware. If the proposed change is to try and avoid redundancies, this should be outlined to employees. So, failure to agree or failure to implement these could result in a worst case scenario, losing your job. So the date the proposed change is anticipated to take effect, whether a proposed change is either a temporary or permanent change, okay? What impact it will have on employees that the employer is seeking to consult, the potential outcome if the change is not accepted, and an incentive being offered, for example, if there is one to be done. Any individual issues then an employee may have with any proposed change should be discussed with the employee with a view to reaching agreement. And you need to be persistent and don't be deterred, like in step 4. Sometimes a no means a yes and all that. They might have resistance and they might have genuine concerns that you can address. Keep notes on file of meetings with each employee, including any issues raised by the employee, any proposals by the employer to overcome these issues. The key is to ensure that employer's conduct is reasonable. So again, we're coming back to reasonable. And document the employer's conduct in the event that the employer needs to prove that they acted reasonably in trying to implement the change. Okay, it's not what you know, it's what you can prove. Prove that you were reasonable with documentation. Draft a consent letter may need to be amended depending on the outcome of consultations. Have employees sign the consent letter and place the signed letter on the employee files. And remember, communication and consultation with employees on any proposed change is key to securing consent and avoiding claims. So those 4 claims under the payment of wages legislation, claims for constructive dismissal, breach of contract, and industrial relations issues. Just as always, to remind you of our toolkit, I'd encourage you all to go onto our Peninsula Ireland Group Limited.com/IE/COVID-19 toolkit, where you'll see guidance on reopening the workplace. It's health and safety guidance in there. We've links to our e-learning schedule, which you can register for. A new schedule will be posted up this week, hopefully for June. We'll have another 2 sessions per week, and we have some e-learning videos to watch back as well. So your coronavirus toolkit, the reopening, is going to be really useful for you as well. I also wanted to draw your attention to our new Back to Work Navigator feature on our Bright HR, and this is a unique tool. So if you have Bright HR and you log in, and you should see this in your Bright HR, it'll allow you to manage the back to work process for you, especially around the return to work safety protocols around staggered shifts, and the other really important process of completing back to work e-learning courses for your employees. One of the return to work safety protocols requires all employers to be reinducted into the business and to be trained on the new protocols. And so there is an e-learning course in there, not only for employees and for employers, and for the lead representative person in the workplace. There's also some great downloadable free resources about redundancy, annual leave, layoff, health and safety, conducting risk assessments. So there's a whole plethora of resource there that I encourage you all. You can also ring the number there if you don't have that, if you don't have Bright HR, and you can find out more about it. Well, that's everything from me today. Thank you all for listening. I hope you found it useful. Let's see, can I get to some of your questions? Okay, so let me see. Is a employee wants to take 3 days per week parental leave, which had been agreed before lockdown. How do I treat this? How do I treat this within the TWSS? Within the TWSS, well, the TWSS is based on January and February's payroll, and the employee had to be on the payroll by the 29th of February. And so in the TWSS, then you're just going to be paying, so they're going to be taking 3 days per week parental leave. So they're only going to, I take it, they'll only be working 2 days. So you're only going to be paying them for the 2 days, because ordinarily parental leave is not paid. So you're looking at your terms and conditions of employment there. So ordinarily parental leave is not paid. So I hope that answered that question. So you'd only be paying them for the 2 days. So whatever, depending on the salary that they're on, you'd only be paying them, and the subsidy that you'd be getting from revenue would only be payment for the days that they're actually working. How will annual leave be affected? We are a childcare service and have been closed since the 12th of March. Well, employees accrue annual leave whilst they're working. If you've been closed since the 12th of March, they're not working, so they're not accruing annual leave. They might have been working from January to, assuming that your annual leave year runs from January to December, they might have accrued hours from January to 12th of March, so they might have an annual leave balance that's outstanding there. But you only accrue annual leave whilst working. I'm going to be doing an e-learning session on that on the 26th of May as well, to get more, and I can give you more information there, but they're not accruing annual leave, so you can't give them annual leave. You only accrue annual leave whilst they're working. Okay, let me see if I've got anything else. A lot of you, you'll all get the copy of the slides later on today, and a link to recording as well. So some of you have probably issues listening to the call or listen to the session today. Don't worry, you can listen back. Do staff automatically have the right to be increased back to 100% subsidy if open, even though revenue is down on last year to, for example, golf course and greenkeepers? Do staff ultimately have the right to be increased back to 100%? Well, it goes back to their contract of employment. The TWSS is to subsidise employers and keep employees on the payroll. So if they're only getting 70%, the TWSS encourages all employers where they can to pay them 100%. So they have a contractual right, as it were, to 100% of their wages as set out in their contract of employment. So if you reopen and they're only getting 70% of their wages, they're not getting 100%. They're entitled to 100%, and so that's a variation to their terms and conditions of employment. And if you haven't sought agreement on that, well, then that's our whole e-learning session. Essentially, there's associated risks, so they could bring a payment of wages claim, or if they raise an internal grievance with yourself and you don't address it accordingly or don't exhaust internal mechanisms, they could bring a constructive dismissal claim. So yes, you'll have to seek agreement on that and come to some sort of agreement there, because that's in a variation to the terms and conditions. Okay, that's all of time for, I'm afraid. If any outstanding questions, I'll make sure that you get answers to everyone today. I'll send on all the slides and a copy of the session later on today. Thank you all very much for listening. Have a great day and speak soon. Thank you.